Welcome to the Attention Deficit Disorder Expert Podcast Series by Attitude Magazine.
Good afternoon, everyone. It's Susan Kaufman at Attitude Magazine, and we're very, very pleased today to have Matt Cohen with us. Matt is an attorney with more than 20 years' experience in special education law. He is the author of several books, has a wonderful website that you should all check out called mattcohenassociates.com, and a blog that's of a great deal of interest to parents. So with that, let me welcome Matt and turn it over to him to give an introduction. Thank you.
I'm really excited to be able to talk to people who are concerned about services for children with ADHD in the public schools. This is a topic that sadly has been one of concern for the last 30 years. It's of concern because ADHD continues to be a diagnosis that remains controversial and one that continues to have significant impact for children, both diagnosed and undiagnosed, within the school system and in their lives in general. The ADHD designation is one that is made typically by clinicians, but is a diagnosis that can also be made by school evaluation teams. Unfortunately, when the law was passed in 1975, ADHD was not specifically identified as one of the disability categories, and the combination of there being controversy and dispute in the society at large as to the legitimacy of ADHD as a diagnosis, and there being no specific reference to ADHD within the special education law, led many schools to take the position that ADHD was not a covered disorder. In the early 2000s, this United States Department of Education finally issued a letter of interpretation to the schools based in part on efforts by CHAD, a National Advocacy Group for Kids with ADHD, and the Public Policy Committee of that organization, which I was a part of, to issue a letter making clear that ADHD might qualify a child for special education services under the category of other health impairment, and that a student might also qualify for protection within the schools under a separate law called Section 504 of the Rehabilitation Act of 1973. And I'll be talking about those laws in just a moment. The sad reality is that even after the U.S. Department of Education made that clarification as a policy statement, there remained considerable controversy about whether kids with ADHD were in fact covered by the schools. And as a consequence of that, in 1999, the U.S. Department of Education modified the regulations for the special education law and expressly incorporated into the regulations the inclusion of ADHD under the special education category of other health impairment, finding that or modifying the definition of other health impairment to include children who suffered from limited strength, vitality, or alertness due to a health condition, including ADHD, which in relation to ADHD led to this is a rather odd way to phrase it, but led to inability to focus on or pay attention to educational tasks due to heightened alertness to environmental stimuli. That was a rather confusing way to word it, but it made it absolutely clear that ADHD was now intended to be covered under the special education laws. But back when the U.S. Department of Education originally addressed this in the policy letter in early 2001, they also indicated that ADHD was a disability that could be covered under a Section 504 plan within the schools. And so there have been two different ways that kids with ADHD now can be protected if they require either services, accommodations, or other protections within the public schools. Unfortunately, however, there are still many, many schools that are confused about the circumstances under which ADHD should be identified, how a child will be identified or diagnosed with ADHD, and what services or protections they're entitled to receive if they have received a diagnosis of ADHD. Many parents continue to be confused, both based on inaccurate or misinformation from schools and their own confusion about whether and how ADHD is protected and kids with ADHD are entitled to services under the special education laws. So the purpose of the discussion today is to talk about the ways that a child with ADHD may qualify for services under both an IEP through special education or through a Section 504 plan if they're entitled to protection under Section 504. And before we get into details, some questions, and I don't seem to have control of the slides yet, but before I go into the slides, you've just got a slide there that indicates how you can reach me. But one of the key things that is important to recognize is that the eligibility criteria for special education are much more detailed and specific than the eligibility criteria are for children with ADHD who may be eligible for a 504 plan. And that's important for people to know because, in effect, if you imagine the pool of people who are eligible under special ed, every student who is eligible for special ed under an IEP, by definition, would be eligible for protection under Section 504. But because the eligibility criteria under Section 504 are broader, there are many children with ADHD who might qualify for a 504 plan that would not qualify for an IEP. And the slide that's in front of you highlights this. There are 3 criteria to qualify for eligibility for special ed, and as a result to qualify for an IEP. You have to meet the criteria for one of the 13 categories of disability to get an IEP, and I just referred to other health impaired as being one of those categories. It's not a category of its own, but under other health impaired, it's referenced as one of the health conditions. The second requirement to qualify for special ed is that the disability has to have an adverse effect on educational performance. This is a place where schools often choose not to give kids eligibility based on the mistaken belief or desire to avoid eligibility because the child with ADHD may be getting passing grades and adequate achievement test scores, even though their behavior may be problematic, their social interactions may be problematic, their ability to function within the classroom may be problematic. So even though the definition for federal qualification for special ed IEP services requires an adverse effect on educational performance, that isn't limited to academics. It includes any area of functioning within the school setting. And then the third criterion for eligibility under special ed is that the child requires special education. And this is kind of circular because, in effect, what the law says is that in order to justify eligibility for special education, you have to need special education. And here the schools also are sometimes either confused or misleading in how they address this with parents, because special education is frequently presented as a service that requires the child to be in a special education classroom. But in reality, special education under the federal law is specially designed instruction that can include any form of specialized service within the regular classroom, as long as there is some element of instructional modification or support that's delivered through the regular education instructional process. So many parents are either scared off from special education or kids with ADHD are denied eligibility based on the mistaken belief that in order to qualify you have to receive services in a special ed setting. And in fact, the law is very clear that the services follow the child into the regular education class rather than requiring that the child have to leave the class in order to receive services. But to sum up, in order to qualify for an IEP, you have to meet the criteria for one of the 13 categories, with other health impaired being the most obvious. The ADHD has to have an adverse effect on some aspect of the child's educational performance, whether academic or otherwise, and the child has to receive some form of special education. By contrast, the criteria for eligibility under Section 504 are much broader. There are no categories of eligibility, so a child meets the definition of disability as long as they have a physical or mental impairment that substantially limits any major life activity, And learning, thinking, and concentrating are specifically identified by Section 504 regulations as being major life activities. For that matter, communication, socialization, and behavioral interaction would be additional major life activities that could potentially be a basis for qualification. And then the additional requirement that's broader than the requirement for an IEP is that you can qualify for a 504 plan if you need special education, related services, or accommodations. Remember that in order to qualify for an IEP, there has to be a requirement that the child needs some form of specialized instruction. By contrast, to qualify for a Section 504 plan, all that you need is either specialized instruction or related services like counseling, nursing services, psychological support or whatever, or accommodations. Many people have the mistaken belief that Section 504 is a law that only provides a right to accommodations, and many schools, when they discuss what a child is entitled to under a 504 plan, only talk about the provision of accommodations. Accommodations are things like extra time on tests, getting a test in a quiet room, or preferential seating. And in many ways, Section 504 is understood to be a law that provides for accommodations. But that is, in fact, one of the great, I would say, myths and legends of eligibility and protection for kids with disabilities, because, in fact, and I'll go into this in the answers to questions, Section 504 provides a right to a free, appropriate public education using somewhat different standards than are provided under special education, but nonetheless, a child may be entitled to specialized instruction. They certainly are entitled to related services, and they're entitled to accommodations. So, for example, if a child requires the administration of medication at school due to their ADHD and requires nursing service to do that, they would be entitled to a 504 plan to get the medication through the school nurse, whereas the use of the school nurse would not be a sufficient educational service to qualify the student under an IEP. So the point that I'm making at the outset, and then we can begin to take questions, is that there are many students who require some special assistance due to their ADHD that would be eligible for the protection of a 504 plan that may not be eligible for the protection of an IEP.
Matt, one of the questions that I'm seeing, hundreds of questions here. One of the common theme here is a number of people who are about to meet with the school, having requested a meeting about special services for their child, and what they're asking is, what should they bring to that meeting?
Well, let me back up for a second, and the first thing that's important is anytime that a parent has concerns that a child might need either special education or a 504 plan, it's a friendly and polite thing to do and a politically wise thing to do to make a call and try to reach out to the person personally to begin with, but they should always follow up those requests in writing and keep a copy of the request so that there's a clear record of the first time, and if they have to make repeated requests, there's a clear record of the multiple attempts to get the school district to follow up on the response seeking evaluation. But if the parent has any outside documentation from either a physician, psychiatrist, psychologist, or therapist that indicates that there are already either formal evaluations documenting the diagnosis of ADHD, those in general should be shared, or even if there is just a letter or an anecdotal report that indicates a suspicion of ADHD from a clinician, that's something that can be shared. In addition, it may be useful for the parent to put together a letter or material that over time provides anecdotal information suggesting why it is that the parent suspects that the child has ADHD that would support the need for the school to do an evaluation. And remember that there are, under the current DSM criteria, which may be changing in the next year or two, but currently a child may have ADHD that's primarily the inattentive distracted type, or the impulsive hyperactive type, or the combined type, and the presentation of symptoms under each of those different subgroups may be very different. Obviously, the kids who are hyperactive or impulsive, it may be more obvious. They're the ones who may be more easily recognized. But if a child, and this is particularly more prevalent with girls, may have the distracted, inattentive variety, it's often the case that that's not fully recognized or noticed by the professional staff at school. And so for the parent to provide anecdotal information or information from other settings that indicates the presence of the symptoms that support the ADHD, that's very helpful. It's also important.
That's a helpful comment, because there is a question here, a very specific question from someone whose 6-year-old daughter was diagnosed by an independent psychologist as ADHD combined type. But she says that in her daughter's IEP meeting last May, the school teachers and the school social workers, quote, talked her out of all the neuropsych recommended accommodations. And yet, she says, and this is to your point about anecdotal evidence, that in the first 6 weeks of school, her daughter lost 4 school books, a permission slip, got lost coming back from the bathroom, and was found wandering the halls and was sent to the principal's office for tackling a classmate.
Oh, my.
So she says, do I fight for more services in this school, or should I move to a private school? I guess there are 2 questions there. One is your point about documenting the things that she's put into this post, I guess, and sending those to the schools, what you're recommending. But how does she handle a school which, essentially denies the results of an independent evaluation?
I think there are probably 3 or 4 questions embedded in that.
Right. Private schools, public school, right, yeah.
Let me begin with respect to the initial point of the role of the independent evaluation and the school district's responsibility in relation to independent evaluation. Schools are required to consider all input from parents regarding a child's disability and what needs they have that arise from the disability, including any outside clinical information that they provide, such as a psychological and neuropsychological evaluation. However, and this is a place where parents oftentimes get confused, consideration is not the same thing as being bound by. And so the school district has to not only look at it, they have to read it, they have to have a legitimate understanding of it, and if they're not going to follow the recommendations, they have to have genuine reasons for why they're not going to follow the recommendations. But they are not legally bound by the private evaluation just because it exists. So some parents go into the school with the private evaluation with the mistaken assumption that that means that they'll automatically get all of the things that the outside evaluator recommends, and that's not the case. On the other hand, if the school doesn't have credible reasons for why the outside evaluator's either diagnosis or evaluation should not be followed, then they're vulnerable if a dispute arises with the parent because they don't have a legitimate basis for refusing those recommendations. Then it may even give rise to the conclusion that they were not seriously considering the outside information. I'd like to jump to the last comment that's raised by the question and then come back to what's in between. But I would say that at the moment, from what limited information is being described, thinking about private school is something of a last resort. So I would work very hard with the public school to try to work things out before I would consider a private school, either as something that the parents paid for themselves, because that's obviously expensive and many parents can't afford to do it, or as something that they would seek as a formal special education placement from the public school at public school expense, because that's also something that is complicated. Public schools are not eager to have to place kids at private schools to receive special ed services, and it's a more restrictive setting that may be more than the child needs. Sadly, private school placement is sometimes necessary not because the child's disability is inherently so severe or complex that they could not be served in the public school, but simply because the public school is unwilling to provide what are actually relatively minor accommodations to help the student, and then a very tragic downward spiral occurs in which the student begins to experience frustration and failure in the face of inadequate accommodation and service. Their behavior and academic performance deteriorate, and then things begin to become of what looks more like a behavioral problem, which could have been more easily addressed if appropriate accommodations had been given at the beginning. Sadly, many of these accommodations, extra time, flexibility on homework assignments, more structure, breaking assignments down, assistance with organizational and time management, improved communication between home and school, positive reinforcement systems to promote appropriate behavior. These are not expensive or complicated things for schools to do, but they do require effort and they require some commitment on the part of the school staff. And if the school is not willing to do these things, all of which are relatively simple to implement, it is all too common that the student's performance does suffer and sometimes does deteriorate into a far more serious situation. Where the school is unwilling to follow the recommendations of the private evaluator, this goes back to the issue of documentation again. And again, before jumping to thinking about private school, not only should the parent document their communications with the school, but they should keep a log of and record of all of the information they receive from the school staff. So every time that a teacher calls to say that Johnny didn't raise his hand, or Sally didn't come to class on time, or Sally spoke out in class without raising her hand or whatever, all of that is anecdotal information that helps to support the fact that in reality the ADHD is adversely affecting the student's performance, and the parent oftentimes may find embedded in the school records a lot of information and data that contradicts the school's conclusion or assertion that it is not having an effect on educational performance. And the key thing for the parent to be aware of is that the school may look to the child's grades and dismiss the issue of adverse effect on performance based on grades or achievement test scores. And it's just very, very important to keep reminding schools that grades and achievement test scores are only one measure of an adverse effect on performance for special ed purposes or a substantial limitation on life activities for 504 purposes. But the school documentation, even the little boxes on the report card that the first or second grader gets that show their progress on reading, writing, and math, typically the report card also has some notation sections for the student's citizenship, class participation, social skills, and so on. And those are the sorts of things that the school may not be looking at when they assess the child's behavior, but in fact may provide documentation that two different stories are being told: the official story that says the child's doing okay, and then the unofficial story that's documented within the school's record itself that says that there really are some problems occurring.
That seems to be a very common story among the questions I'm receiving. I mean, kids who are told, parents who are told that the child's grades are too high, but yet they're reporting, tremendous difficulties in terms of following instructions or being distracted, whatever. So that sounds like really good advice.
This is a very important point, and one of the things that it's important for both parents and clinicians and educators to be aware of is that kids with ADHD, there's no correlation between intellectual ability and ADHD, so you can be very bright and have ADHD, you can be average, and you can even be cognitively impaired and have ADHD. So the range of intellectual and academic ability is quite wide, but the school is simply not operating consistent with the law if they take the position that because the student is academically performing, that means that they're not eligible. The special ed law and 504 both make very clear that the school should base eligibility decisions on the student's overall functioning at school, not just based on academic performance or academic achievement. And incidentally, that may express itself in terms of behavioral problems. It may express itself in terms of social problems, because many kids with ADHD may be socially isolated because they frequently may either be withdrawn if they're inattentive or distracted, or they may have behaviors that are frankly obnoxious or unappealing to other kids that tend to cause them to be socially isolated. But there's another category of behavior that schools frequently don't pay attention to, especially for kids who are getting reasonable grades, and that's what I would call academic behavioral problems, to wit, The child has trouble with time management on assignments. The child has trouble with getting the work in on time. The child talks out of turn in class. The child's work is not well edited or proofread, so even though the content is great, the quality of the production of the work is not good. And schools may ignore these things because the child does well on tests and ends up with good grades on the report card. But these are all academic behaviors that can be symptoms of ADHD. Just to share briefly a story, my conviction, and I deal with kids with disabilities across all disability areas, but one of the things that makes me saddest is that there seems to be what I call the homework gremlin. And the homework gremlin comes into play frequently for students with ADHD and other attentional and neurobiological problems. The child has trouble getting the assignment down, so structures are put into place to make sure the assignments are recorded. They go home to the parent, and the parent dutifully works hard with the child, painfully, sometimes tearfully or angrily. The child completes the homework, usually taking far more time than would be typical for other students. The parent checks to make sure that the homework is in the child's backpack when they are on their way to school. The school checks the backpack when the student arrives at school to make sure it's there. And then
I know where this is going to end, yeah.
somehow, somewhere, somehow, we just don't know except for the homework gremlin, when that child arrives in class and goes to turn in the assignment has disappeared and the student ends up getting a 0 despite the blood, sweat, and tears that the student, parent, and even staff have exerted to try to get the homework done the night before. And that is a pattern that happens just over and over and over again with kids, both many different kids, but I look at many kids' academic records, and that homework gremlin has led to them getting substantially lower grades because many of their assignments are either lost or turned in late because they were swallowed by that homework gremlin. And this is something that is academic behavior that would by itself demonstrate adverse effect on educational performance and a potential basis for either special ed or 504 eligibility. Probably not by itself as a disability, but certainly as evidence of the adverse effect of the disability.
Sounds like you know our kids pretty well.
I've been there myself. In fact, I have ADHD, and the homework gremlin stalked me throughout my school career.
To this point of the school just sort of, there are numerous questions here from people who say the school just does not believe that 504 plans apply to kids who are doing well in school. I mean, there are just numerous, 20 people here who are experiencing that. And as you said, that's just incorrect. But what should they do? Should they bring a copy of the law in? Should they,
well,
I mean...
there are a number of things they can do. The first is, unfortunately, we assume that the schools have a good understanding of what their legal obligations are, and that's sometimes true at the administrative level and not at the level of the line staff, and sometimes there are explicit decisions that the school doesn't want to deal with certain types of disabilities, so there's actually an overt decision to kind of deflect kids, and sometimes even at the administrative level there's confusion about what the law provides. But one of the things to do is to contact the State Board of Education or Department of Public Instruction to ask for clarification, because the state agencies tend to understand that the right to services goes beyond academics, and they may have policies that support the federal interpretation. There is, and this can be Googled or through the U.S. Department of Education, there are a number of policy letters that the Department of Education issued that made clear that there is a right to service even if you get passing grades. And in fact, in the federal special education law, IDEA, there's a specific reference that the fact that the student is receiving passing grades does not necessarily mean that they are getting an appropriate education. That speaks more to the quality of services than to the entitlement to service. The other thing that can be done is it's possible to file complaints either with the state education agency or with the U.S. Department Office for Civil Rights under 504, noting that the school has a policy that they won't regard a student as eligible if they're doing well academically. And as I say, that's just not legally supported.
Right. Now, there are a whole series of questions here about what services a family is entitled to if they do have an IEP or a 504. Specifically, people want to know about should they be entitled to tutoring or tutoring outside of school, or, for example, therapy for sensory integration disorder or behavior or biofeedback or other kinds of therapies that might take place in a non-school setting.
Well, if we could go to the slide that has IEP and 504 plans, and both of them say includes at the top. As you can see, both of these, there are two columns there that describe the entitlement to services under an IEP and a 504 plan. Both of those require that students receive what are called related services that are necessary for the student to benefit from education. And this is in many ways an opportunity and in some ways a challenge, because under both laws there's no limit on what the related services are that a student could be eligible for in order to benefit from education. The special ed law delineates a longer list, including transportation, speech and language service, social work, psychology, orientation and mobility, parent counseling, nursing, and so on. The 504 regulations specifically reference counseling services and transportation, but whatever services are delineated as examples, not as an exclusive list. So there are a whole variety of other services, and tutoring might be an example of that a child might be eligible for if it's necessary for them to either benefit from education under an IEP or to participate effectively in education under a 504 plan. On the other hand, parents need to be aware that just because they have a good idea or a wish for something to be done, or even if they have a clinical expert who's recommending that something be done, under both laws, there's not an automatic entitlement to whatever the parent wants, nor is there even an automatic entitlement to a service because an outside expert recommends it. The school has to determine that the service is necessary. And if we can go back to the slide that references free appropriate public education at the top. So the critical term under both laws is that the students are entitled to receive a free appropriate public education. Under the special ed law, what the free appropriate public education includes is delineated in the IEP or individualized educational program. What the free appropriate public education includes under Section 504 is delineated within the Section 504 plan. The key thing here, though, is that the students under both laws, based on court interpretation, are entitled to what's necessary for them to receive some meaningful educational benefit rather than what's necessary for them to make the most or best progress possible. So it's important for parents when they're asking for things from the schools to recognize that there's a difference between things that the school might provide that would be helpful or might be a nice idea or might optimize the student's performance, which the school could choose to do but are not legally required to do, and those things that are absolutely necessary for the student to make meaningful progress. And so parents should try to focus on talking to the schools in relation to what's necessary rather than what's ideal, optimal, or best. The other thing that's important for parents to realize, and again, this is a place where many parents end up feeling very frustrated, is that the fact that the parent believes it's necessary or asks that it be done or even has clinical support for the fact that it's necessary doesn't mean that the school has to agree. And so whether it's under an IEP or under a Section 504 plan, the school team has to assess the information and the request and make their own decision as to whether the service is necessary or not. And then if there's a disagreement as to whether the service is necessary, the recourse that the parent has if they don't get the service that they feel is necessary is under the special ed law, they can request what's called a due process hearing to try to prove that the service is necessary. And under Section 504, they actually have two options. One is that they can request a due process hearing from the school, or the second option is that they can file a complaint with the U.S. Department of Education Office for Civil Rights, alleging that the school is not providing adequate services for the child under 504. But in either event, it's just very important for the parents to realize that something that's common sense or seems obvious, or even that's being recommended by a private expert, doesn't automatically mean that the school has to do it. And because of this differential between what's best and what's necessary, a school could even acknowledge that a service would be helpful, but take the position that while it might be helpful, it's not needed, and therefore they're not going to provide it.
Well, this brings us perhaps to a question from Larry, who asks, under what circumstances do you recommend parents come to an IEP or 504 meeting with legal counsel?
I think before I answer that question, I would suggest something at a broader level, which is that the school has a lot of power and has many students that they're responsible for, and has many different things that go into the decision making about what they're going to do in relation to a particular student. It is always advisable for the parent to try to work cooperatively and collaboratively with the school to the extent possible, to work out problems without having to get a lawyer or get into a legal or adversarial situation, and to try to maintain and build an alliance, a positive working relationship with the school staff. It's also very, very important for the parents, if they're feeling like there's a conflict, the conflict can play out in a number of different ways. If the conflict is with an individual teacher, it's useful for the parent, to the extent that they can, to try to work out the problems first with that teacher, again without having a lawyer, and then if they can reach out to supervisors or administrators to try to work out the problem at a private level, preferably without lawyers. As with anything else in the world, these are bureaucracies and people's egos are at stake, and if it's possible to work the problem out without putting the whole school staff on notice that there's a conflict with this particular teacher, or perception that the teacher or provider is unprofessional or incompetent or hostile or whatever, it's often more likely that the problem can get worked out in a face-saving way by the administrator. If the parent has to raise the issue publicly at an IEP or 504 meeting, there's frequently a natural reaction on the part of the administrators to circle the wagons, and they need to defend their staff, and so it's going to be harder for them to solve the problem if the problem goes public at the outset. But unfortunately, either when the parent has tried to deal with those problems, and by the way, the other thing I would say is that sometimes there are problems that arise really at the administrative level, that the administration says, we won't provide aids for kids with ADHD, or we won't provide nursing services, or we don't believe that you qualify for service if you're getting good grades, even though you've got ADHD that's causing problems socially. Those are administrative problems. And when that happens, the parent should take a different approach, which is to deal with the administration directly around the dispute, but to try to work as hard as they can to maintain a positive relationship with the line staff. In other words, to try to avoid getting the line staff caught in the middle when it's really not a problem that the line staff are doing something wrong. They're just following the directions of the administration. So to the extent that the parent can make clear that their grievance is not with the particular teacher, it's with the system or with the policy, and that they recognize that the teacher is caught in the middle, that can be very important in terms of maintaining relationships on an ongoing basis. But where the parent is not able to solve those problems informally, either at the teacher level or at the administrative level, that's the point at which getting a knowledgeable advocate or an attorney involved may be very useful. A second circumstance where it may be very useful is when the student is facing disciplinary problems. Probably I'm more inclined to get attorneys or advocates involved more quickly when a student is at risk of exclusion from school or transfer to a more restrictive setting based on behavior. And under those circumstances, because the stakes are very high, it may be useful to get an advocate or an attorney involved more quickly. And then a third instance where getting an advocate or an attorney involved more quickly may be advisable is when there's a lot of hostility or emotionality that's developed between the parent and the school, and it appears that just the communication has broken down to such an extent that there can't even be a rational discussion. It is oftentimes intimidating or threatening for schools when parents bring an advocate or an attorney in, and parents should realize that it's likely that if they do bring an advocate or an attorney, the school will get an attorney of their own to represent them. By the way, I should mention that that would be another circumstance where it's wise for the parent to consult with an attorney is if the school starts to bring their attorney to a 504 and IEP meeting when the parent hasn't had an advocate or an attorney involved. That's usually a clue that the school perceives there to be a big problem, and it's a smart thing for the parent at that point, if they can, to get a knowledgeable advocate or an attorney involved, because the school is clearly, from their standpoint, perceiving that there's a conflict that requires legal involvement. By the way, I'm specifically qualifying the answer to the question, which was about attorneys, to also include advocates and to also include knowledgeable, because there are many people who are advocates who do very good work and who are extremely experienced, but there are also people who describe themselves as advocates or maybe informal advocates who really are not particularly knowledgeable or experienced, or who may have their own set of issues or agenda with the school. And so you want to make sure if you're bringing an advocate that it's someone who is knowledgeable and who is really there to assist the parent with their agenda. And similarly, it may be helpful to bring an attorney even if they're not knowledgeable about special ed, just because they may be knowledgeable about the law generally and about what schools are supposed to do in terms of protecting people's rights. But if you bring a real estate lawyer to an IEP meeting, they're not going to be nearly as useful as an attorney who has experience with special ed. Sadly, there just aren't enough of us out there, so sometimes parents either can't find people with experience or find people that they can afford. And one of the things for people to be aware of is that there are a couple of organizations that are worth looking at if you're trying to find attorneys or advocates, low-cost or private attorneys. One is the Council of Parents, Attorneys, and Advocates, COPA. COPAA has a search engine for lawyers who do special ed work around the country. The second is the website is www.ndrn.org, which is the National Disability Rights Network, which is a federally funded network of state disability advocacy groups that can provide services to kids and families with kids with special ed needs. And the third is that there are parent training centers that are federally funded throughout the United States, and they may either be able to provide advocates or at least referrals to advocates or lawyers. And the search engine to get access to that, to your parent training center in your area, is technicalalliance.org or talliance.org, but in any event, it's the Technical Alliance website for the parent training centers, and they have a search engine for all of the parent training centers in the U.S.
Well, that's great. By the way, you have a supporter here in Francie who's a peer navigator in South Dakota, and she's posting to say to you that one of the biggest problems she has is when schools refuse to help with the gremlin problem. She says teachers pass the blame onto the parents' organizational skills and don't feel that they should have to deal with kids who can't get their homework to school. So she's citing the gremlin problem as one of her number one challenges.
Let me just add, by the way, that there's one other source of legal assistance that parents should be aware of, which is that under the special education law, schools are required by law to have available a list of low-cost or no-cost legal services within the state. And if the parent asks the school, they're entitled to get that list, and if for some reason the school doesn't offer it or doesn't have it, the State Department of Education would have that. And even if that list doesn't produce a person or lawyer or advocate who can provide services, and some of them also have income requirements and other qualification requirements to get service, and certainly they all have heavy caseloads. That list of low-cost services, at least those agencies can also help to direct the parent to public or private lawyers that they might find not on the list.
A couple of interesting questions here about as kids move through the school system. There are some families here whose kids have had IEPs or 504 plans who have done well with support, with medication, with tutoring, and yet when they move to high school or they move farther on, there's a suggestion that they no longer need those services, and they're asking how do they respond to that when indeed they know that the support system and the services that they put in place are exactly what has helped the child succeed. And similarly, kids who have succeeded without a formal plan but have gotten through elementary school or whatever level and then get to the next level and suddenly, find themselves floundering and the school says, well, you never needed services before, why should you need it now? So both sides of that transition problem.
Well, as lawyers, we would call that a compound question. I think there were 6 elements to that, and maybe we should schedule a session on transition services for people at a later date. But that really involved multiple different elements that are not even entirely related. But I didn't even throw the college questions at you. Let's leave college out of it for the time being, because that's really a whole discrete category of its own. But the first thing is that although technically the DSM currently requires that kids show symptoms before the age of 6, you can be diagnosed with ADHD at any time up through adulthood. And the DSM-5 that's expected to come out, it's expected that the age threshold at which you display symptoms is going to be increased substantially. So that's an important point clinically. The second thing is that it's very clear that the demands of school become greater every year, and ADHD is a spectrum disorder, which means that it's not as though there's a blood test and you either have the measles or you don't have the measles. It's a disorder that can manifest itself with varying degrees of severity, both over time and based on circumstances. And there are many kids who will be either asymptomatic or have subclinical symptoms when the demands are less, but as the demands grow, the symptoms become more prominent and disruptive and impactful in terms of their functioning. And even kids without disabilities, the whole notion of the progression of the curriculum and educational system from kindergarten to high school is that the expectations and demands grow substantially as the child progresses developmentally. It's also relevant to know, many people may not be aware of this, but the research indicates that although kids with ADHD ultimately can develop to a level comparable to their age mates, that there is what's estimated to be a 2 to 5 year developmental lag for kids with ADHD in some areas of their development, so that they may not reach the same level of maturation that you would see in high school until they're actually in college or beyond. And so it's not at all unusual that the symptoms of ADHD may show up more severely as the kid gets older. The fact that the child has not had problems earlier, again, may be substantially situationally related and demand related rather than because the child didn't actually have the disorder. ADHD is not something that's contagious. You don't catch it. It's something neurological that you either have or you don't have, though there are a variety of other disorders that may have symptoms that overlap with ADHD. But there's a lot of basis that indicates that people may be able to manage either through self-compensatory skills, informal compensatory skills, or because they're bright or capable in other ways, so they're able to get by in earlier grades, and then it's only when the demands increase that they begin to show the symptoms in a more significant way. People can be diagnosed in adulthood who've gone all the way through school without being diagnosed or formally recognized, but when you go back and look at the student's records, you discover that there were indications of the disorder. I'm a successful lawyer. I've been practicing law for 31 years, and I've got lots of things that would suggest I'm a highly successful professional. I recently had the opportunity to discover my elementary school report cards in my parents' basement when we were moving them to a retirement facility, and it was interesting to see the contrast between my grades and the parts of the report card that reflected on behavior. And was that, in fact, although I got good grades, I did talk out of turn. I had lots to say, and the teachers enjoyed that I had lots to say, but often had difficulty getting me to shut up. And I could go through a variety of other symptoms that were reflected in those early narratives that while I was academically successful in elementary school, didn't manifest themselves as things that were regarded as academic problems. But then in high school, my grades did deteriorate. I was successful enough to get into college and go on to law school and so on, but my organizational and attentional skills, or deficits rather, did have greater effect, even though I was still, at least by comparative standards, a successful student. So the fact that the symptoms are not totally apparent at whatever stage doesn't mean that the disorder isn't present. The other thing that frequently happens, people will say that the student shows a high ability to concentrate and to perform under certain circumstances. Gee whiz, they're playing video games or using the computer for hours and hours successfully. Why would we view them as having ADHD if they're able to do that successfully? And one of the other things that research indicates is that kids respond, adults respond to high stimulus situations and have much more great difficulty with things that are low stimulus, boring, or actually things that they have difficulty processing. Now that's true of everybody, and so many people will say, yeah, sure, everybody has more trouble when they're bored, but the point in relation to people with ADHD is that they have demonstrable degree of difficulty that is outside of the norm of what everyone else would suffer when they're bored, distracted, or engaged in an activity that isn't interesting to them.
That's really helpful. Here, we're getting toward the end here, so I'm just going to give one very specific, one person's question, maybe to bring that down at a very practical level. She says her 16-year-old son was diagnosed a year and a half ago with ADD, and the school refuses to put any accommodations in place. He does well with lots of support on homework and testing, but every time he takes a test, he goes down 2 grade levels because he just simply has a block. Her concern is that because the school hasn't put any accommodations in place, she's concerned that the college board will also be unlikely to make accommodations, and he has the SAT coming up. Go ahead.
Well, it is the case that the college boards and all of the testing services look for clinical documentation of disability, that the disability is sufficiently severe to put the person at an impaired level in comparison to the general population, that it does, in fact, adversely affect their performance or limit their performance and functioning, including at school, and that they require accommodation. The fact that they have not gotten formally recognized or received accommodation is not by itself a basis for the board to deny the accommodations when they apply, but it would certainly be evidence that is viewed as significant by the board in suggesting that they don't need accommodation. Similarly, the fact that a student has received accommodation in the past by the school does not automatically mean that the board will agree and give accommodation, though it's more likely that they will. One of the things that this speaks to is the importance of the parents keeping anecdotal records of the supports that have been provided. The other thing that I haven't mentioned earlier that I might have mentioned in relation to one of the earlier questions is that the Americans with Disabilities Act and Section 504 both have incorporated a provision that says that you cannot deny a person eligibility as a person with a disability if the use of mitigating measures, such as medication or special supports, have allowed them to perform at an adequate level when without those mitigating measures they would not have been able to perform at an adequate level. And many schools and sometimes the boards miss the fact that there may have been lots of mitigating measures in place. In the educational world, that's also referred to as scaffolding, and there are many types of scaffolding or support that are provided. Some are formal and some are informal, including just the parent checking to make sure that the kid has done their homework every night. That's an external support. And when you are looking at a child in high school, it's very important to be aware of the fact that how they perform with scaffolding may distort the impression of the impact of their disability, because the scaffolding allows them to function at a higher level than they would if the scaffolding were not there, and so it in effect creates an inflated picture of their functional ability. And that's something that should be documented, should be part of the discussion with the school and part of the discussion with the testing agencies. But it is much more likely that a student will qualify for accommodations on the various national tests if they've already been recognized as having a disability by the school and have been receiving accommodations. It's not that that's impossible without that, it's just much more likely. So the earlier that you can get appropriate evaluation and get accommodations in place, the better.
I'm going to close with one last very poignant question. So this is from Nadine. Do you have advice for parents of a second grade boy with ADHD whose school consistently punishes him for his impulsivity by putting him on red and forcing him to sit inside during recess? That's terrible. Really, you know terrible.
What? That's one of those real tragedies, and it's a very common phenomenon, a knee-jerk phenomenon in schools. And there actually is also research indicating that recess is actually very important for all kids, but it's especially important for kids with ADHD because they do have a need for the opportunity to release and discharge some of the hyperactive elements of their disability. And many kids with ADHD do have social problems, and resources and opportunity for them to practice and develop social relationships. The school, if the child is eligible for an IEP or a 504 plan, there are different language under both laws, but the school is supposed to consider what are called positive interventions and supports to address the child's disability, and punitive or exclusionary steps like exclusion from recess would be described as reactive or punitive strategies that generally are both educationally and clinically unsound and arguably incorrect from a legal standpoint in relation to developing appropriate responses to the behavior.
Okay, well, Matt, I can't thank you enough for your time. What you're doing is great work, and our many families can attest to that. But there are questions. I hope we'll be able to schedule a follow-up because there are just lots more questions here that need addressing. But thank you so much.
People can email me. There is a portal through our website for people to send emails. I don't know if my individual email address is listed, but our website has a contact mechanism if they have questions.
Okay, thanks again. Goodbye, everyone.
Hope it was helpful.
For more Attitude Podcast and information on living well with attention deficit, visit attitudemag.com. That's ADDITUDEMAG.com.